The market capitalization of the coin is used to summarize all that is taught in this video. Additionally, I would ask that you support my channel by liking it and subscribing to it so that you can stay up to date on future XRP news, as well as other cryptocurrency news in general. Let's take a look at this right now. There are only a few days left for the SEC to file an appeal against the verdict that rippled. Before we go any further, there is a new cryptocurrency airdrop that is now taking place and is very close to being launched in the near future. It is imperative that you ensure that you take part in the airdrop and visit the URL provided in the video's description. Make sure you don't miss out on this opportunity. Alright, let's go with our video. The United States Securities and Exchange Commission has only a few days to submit an appeal against a ruling that recognized secondary XRP sales as non-securities. This verdict has been the subject of a significant deal of discussion, and it has been the subject of substantial debate. October 7th has been designated as the date for the requirement to be met. According to a source, a former attorney for the Securities and Exchange Commission (SEC) believes that the government would challenge the ruling. In a similar vein, Mark Powers, an experienced enforcement attorney working for the Securities and Exchange Commission, is of the opinion that the SEC will ultimately appeal the verdict. The ruling that Judge Annalise Satora has handed down has been regarded as a big victory by Ripple. This is because it has provided the XRP coin with some type of legal clarity. The technique that Torres employs, which distinguishes between programmatic and institutional token sales, has not, on the other hand, garnered a significant degree of popularity. For instance, during the course of the Ripple case, United States District Judge Jed Rakoff ruled that it should be dismissed. Powers believes that the SEC will file an appeal against the former deputy chief. Powers believes that this will resolve the contradictions. During an interview that took place in August, Stuart Alderode, also known as the top legal mind of Ripple, did not completely rule out the prospect of filing an appeal with the SEC. On the other hand, he is of the opinion that such an appeal will not play any role in influencing the legal position of the former Sir Procon. The organization has been subjected to scathing criticism on many times due to the fact that it has persistently refused to provide the sector with defined standards. On the other hand, the Securities and Exchange Commission has stated that the restrictions that are now in place regarding securities are sufficient, and that individuals who are involved in the cryptocurrency industry are obligated to comply with these regulations. In a recent statement, Gary Gensler, the chair of the Securities and Exchange Commission, issued a forecast that the business would not continue to exist in the absence of regulation. The structure of the Securities and Exchange Commission is becoming closer and closer. The legal battle that Ripple is currently engaged in with the Securities and Exchange Commission (CSE) in the United States is growing increasingly intense. Concerns have been raised among members of the cryptocurrency community in anticipation of a late-stage appeal that has the potential to extend the ongoing discussion on XRP and other crypto assets. Would there be any advantages to collaborating with the SEC? Specifically in light of the concerns expressed by Mark Fagel, a former attorney for the Securities and Exchange Commission. Eleanor Terrett, a reporter for Fox Business, recently made some observations that suggest the Securities and Exchange Commission may have a strong case for its position. These observations were made in light of the fact that Fagel aired his worries. The former employees of the commission are of the opinion that the organization maintains a good attitude. He voiced his disagreement with the decision that Judge Torres made in July 2023, stating that it contains misunderstandings regarding the procurement of XRP tokens. He stated his displeasure of the verdict. When it comes to proving that Ripple's promotional activities resulted in buyers having an expectation of profit, the SEC is having a difficult time because there is not enough information. To add insult to injury, this uncertainty brings to light the potential strategy that the SEC could use. The cryptocurrency XRP is going to be closely monitored by traders, right? During this particular legal process, James Farrell, a separate attorney who had previously worked for the Securities and Exchange Commission, emphasizes the benefits that the SEC possesses. Farrell made the observation that the Court of Appeals employs a review procedure known as de novo, which enables the reevaluation of evidence in a manner that is independent of the conclusions that Judge Torres has reached. It is now possible for the Securities and Exchange Commission (SEC) to reintroduce testimonies that were previously rejected in order to bolster its case. As a consequence of this, the new review procedure has the ability to significantly enhance the position of the SEC while simultaneously having an impact on the outcomes of the case. Taking into consideration the current state of affairs, the following are some significant takeaways. As a result of the potential that the earlier verdict contained errors, there is a chance that the Securities and Exchange Commission has a strong case. As a result of the de novo examination, the Securities and Exchange Commission will have the opportunity to strengthen its accusations. Despite the fact that Ripple's leadership continues to radiate confidence, the chance of an appeal is still present. The leadership of Ripple, including CEO Brad Garlinghouse, continues to maintain that the XRP case is over, which makes it plausible that an appeal will not take place. A few individuals who are part of the cryptocurrency community, however, it is important to maintain a healthy level of skepticism and to be prepared for the possibility of a last-minute appeal to the SEC, which might potentially delay the settlement of the issue. During this interim period, market participants are keeping a close eye on the variations in the price of XRP in order to obtain insights about the potential path that the case could take. According to the ongoing judicial processes, the outcome of the lawsuit may have a significant influence on the cryptocurrency market, particularly with regard to XRP. The approaching likelihood of an appeal being filed with the SEC adds an additional layer of uncertainty, which causes traders to be watchful for any developments that might potentially influence the dynamics of the market. Traders are alert for any developments that could potentially influence the market. An increasing amount of attention is being paid to the subject that is now being contested between Ripple and the United States Securities and Exchange Commission. This is due to the fact that the deadline for a potential appeal is drawing closer. Those who are involved in the cryptocurrency industry are anticipating that the Securities and Exchange Commission (SEC) will submit a last-minute appeal in the XRP case. This has the potential to lengthen the duration of the legal war that is surrounding crypto assets. According to a recent post written by Eleanor Tourette, a reporter for Fox Business, the Securities and Exchange Commission (SEC) may have a fair case, which might be a possible advantage for the SEC. People who have worked for the Securities and Exchange Commission in the past are of the opinion that the agency is currently in a favorable position, due to the fact that they feel the ruling that dealt with the sales of XRP program tokens contained an instance of error. As someone who had previously served as an attorney for the Securities and Exchange Commission (SEC), Mark Fagel expressed concern in response to the decision that Judge Torres made in July 2023 on the Ripple SEC case. Despite the fact that we are of the opinion that the decision was made in error, the agency is hesitating since there is a potential that the appeal may not be successful. Fagel made the observation that the appeal for the Securities and Exchange Commission (SEC) indicates the agency's concerns and calls attention to potential weaknesses in the ruling. The agency's position in the case is weakened since it is unable to present sufficient evidence that Ripple delivered promotional materials to clients. To be more explicit, this is the reason why the agency's position is undermined. It was determined by the judge that the Securities and Exchange Commission (SEC) was unable to prove that buyers had a reasonable expectation of profit based on Ripple's efforts because there were no recorded relationships between the parties. This was due to the fact that the SEC was unable to demonstrate any connections. The prices of XRP and extra former attorneys for the Securities and Exchange Commission are two things that traders pay close attention to because of their importance. James Farrell emphasized that the Securities and Exchange Commission (SEC) possesses significant advantages during the process of litigation. It was brought to Farrell's attention that the appellate court operated under a de novo standard of review, which means that it has the ability to re-evaluate evidence without taking into consideration the findings that Judge Torres reached. With the implementation of this new review procedure, the government agency might be able to present testimony that had been disregarded in the past. It is to the advantage of the SEC that this takes place. It is possible that the Securities and Exchange Commission would be able to acquire a big advantage in the legal process with the amended appraisal. This would allow them to gain tremendous authority in the case. The likelihood that the agency will be successful in obtaining a favorable conclusion in the proceedings of the appellate court is not minor as a consequence of this. In a statement, Ripple's top legal officer has made this assertion. It should be noted that the material that has been supplied is not intended to serve as business advice. In the event that any investments are made on the basis of the information that is provided on this page, there is no responsibility for those investments. Prior to making any choice on investments, we strongly recommend performing independent research and talking with a professional who is educated